United States, the legal profession sort of drove the evolution of intellectual property law. We would work with engineers, we'd work with researchers, they'd have new ideas, new technology, and we'd find a new way to protect it.
那本来智慧财产权是来保护科技，从很多的方式、很多的角度，跟研发人员、跟科技人员跟创新发明做很完善的一个保护。
But recently, in the last few years, especially in the United States, that started to change. We still do that. We still find unique ways, novel ways to protect technology. But at the same time, technology and intellectual property is starting to change the legal profession.
以前我们都是用法律来保护科技，然后让科技在，比如说以前软件不能申请专利的时候，我就把它放在装置里面来申请。可是现在不一样了，现在是科技要来微调、扭转法律的一个进展，所以它要从这些方向来跟大家做一个分享。
So as I said earlier, because there is some degree of harmonization, as we start to see these changes in the U.S., we've already started to see them in other countries as well. So for example, some of the issues we'll talk about in a moment, we started to see with my colleagues in the United Kingdom. I think in the presentation about RICO's intellectual property program, we start to see some of those things too. So it's causing a question of what does it mean to be an intellectual property lawyer, an intellectual property attorney, in the United States or around the world, because IP is around the world.
那智慧财产权其实是一个全球性保护的一个议题，所以他很多时候也会跟各国的律师、各国的专家来做一个交互的切磋学习。
So, for example, some examples in the past of the legal profession driving change. You would think of the three primary areas of intellectual property law: copyright, patent, and trademark. So in the United States, historically over the last 20 years, 30, 40 years now, for example, in copyright, they developed new policies concerning time shifting and space shifting with DVRs and VCRs.
那智慧财产权包括了专利、商标，这个著作权。那大家知道，连著作权都会与时俱进，跟着不同的法律策略国且很多的重要的议题出现的时候，它都会改变。
And the same thing happened with respect to patents as well. In the United States, the legal profession drove change at a policy level such that we could start to begin to protect software, which that's sometimes is good, sometimes it's bad. But at the same time, the law in the United States at one point allowed you to patent basically, literally the law was anything under the sun.
那专利也是一样的，法律有进步性，专利法也一样有进步性。从以前软件是不能保护到前面说我们把软件依附在一些装置上，到现在专利是在很多的他说太阳下看到的一些创新发明都可以来申请专利保护了。
And then the last example with trademarks is in the United States there have been policy changes, the legal profession pushed changes in the law to be able to protect things that were typically outside of logos or brands, but smells, colors, and sounds.
就连商标也不再是以前的这个看得到的商标物件，甚至味道、颜色、声音都可以拿来做保护。
So we have in the United States now and around the world, but in the United States specifically with respect to what I'm talking about, I kind of see as sort of the new intellectual property. We still have patents, we still have copyrights, we still have trademarks, but we have these new 3 or 4 classes of innovation in technology, intellectual property, that I think will fundamentally change the way, and already have fundamentally changed the way we practice law, and I think you'll start to see how it's practiced around the world as well.
那其实有一些新兴科技已经开始改变了法律一些以前执行业务的方式，那么他也要跟大家做这些的分享。
And those, as you can see here, are artificial intelligence and machine learning, big data and analytics, automation, and then what we call in the United States DIY, do-it-yourself law, so people that aren't lawyers can be kind of doing law, and then chatbots, and then issues related to privacy and data security for what we refer to now as virtual lawyers.
那比如说，最明显的就是人工智慧、机械学习、大数据分析、预测的统计，还有自动化。那说一些 DIY 的这个法律，或者是我们说像小米的小爱同学这一类AI 机器人回答你这些的技术。那另外就是隐私权、资料安全，这些是慢慢的都在整个法律业务的执行当中，对律师的习惯上做了很大的一个冲击跟改变。
So the first category, this first new sort of intellectual property that's driving a change in the profession is AI and machine learning.
他觉得目前比较大的变革已经让整个法律执行业务的方式变化了，就是人工智能跟机械学习。
So the first example of this is patent drafting. This is a very real, very current example. In the past, you wanted to get a patent, the attorney would go and meet with the engineer, meet with the researcher, have a conversation, read some documents, understand the invention, then go back and write a patent application.
以前我们写专利都是我们去见发明人，然后他告诉我们他的创意、他的创新，他做了哪些实验数据，然后回来读一点资料，然后根据以前的经验，然后在家里做这个撰写。
So while that still happens, there's this very large push in the United States now. A number of companies are developing technology where you just write a claim. So the claim's at the end of the patent application. And then a program will write the patent application for you. And in some instances, even create the drawings.
那现在呢改变了，因为那样太花时间花钱太慢了。你只要这个帮忙把权利项写出来，其他因为权利项已经把标准的技术跟专利的 keyword 写出来，它就让机器去把剩下的部分写好，甚至连图示都可以叫机器化。
Now this technology is based fundamentally on machine learning, where the software program writes the first application, then it writes another, then it writes another. And it learns based on these different technologies, and it continues to build. But this starts to pose a whole new series of challenges, both legally and ethically.
那另外就是机械学习，一版一版的去教它，所以它会写得越来越好，就好像AlphaGo最后下棋会打赢人。但是这里面产生一个议题，就是到底专利是谁写出来的？
So, for example, a patent application is supposed to cover something new and not obvious. But how do you teach a program something new? If it's going to learn, what is it learning from? What's the new aspect?
因为我们说专利就是要新颖性，而且非显而易见。但是如果你是叫机器学，机器一定是学习旧资讯，然后来做一个整合。那这样是不是真的创新呢？
So these programs that are doing this patent drafting, this automated patent drafting, there's challenges in that they're either learning from the prior art, which at that point there's questions of, is it really drafting something new, or is it just copying the prior art and putting things together?
那本来呢，我们说要新颖性非显而易见性，可是你叫它一定是从旧的资讯你抛进去，然后它可能把好几件抛在一块，然后这样子就有新颖性，有这个非显而易见性。
And then there's a separate challenge and a more ethical challenge in that some of these companies that sell the software, they have a big database that it learns from. But a first company will write its application, then a second company, then a third, and it all goes into this database. And the challenge is, can the machine learn from different companies' intellectual property? Is it okay to learn, for the second application to learn from the first, from the third application to learn from the second and the first? You're, in a sense, are you misappropriating somebody else's intellectual property to train the machine to understand that technological space?
那其实像刚刚他们说，刚刚谢总就说，如果你一年要写12个专利很困难，可是我直接就想到了无法fire search完，就像他讲的，这家公司那家东西做一做拼一拼，然后我补一点新资讯，做一点新实验，我 design 和 run 过来，那这样子是不是道德上面有一点点问题呢？
So that's a first example of a big change that a number of clients in the United States, and these are large companies that use this technology, companies like Cisco, companies like Disney, that have very real, very large intellectual property portfolios. They're wanting to use this new technology, and there's questions of, A, how good is the technology? Does it really write a good patent application? And B, is it ethical or legally okay to do so based on how it's learning? Because these companies don't tell you how their machine learning algorithm actually works.
然后比如说像 Cisco 或者他说像迪士尼一些很大数据库的公司，他就从自己旧的专利里面拼拼凑凑学习，让机器学习，再学习其他公司的，然后机器学习其实写出来的专利已经挺不错了。那这样子的时候，是不是也会产生一些的问题？他也不会告诉你他的机器学习的程式是怎么写出来的。
So a second new technology or intellectual property we're seeing with AI is smart contracts, where it's essentially an agreement that's reduced to an algorithm or a program or a flowchart, and it automatically locks the parties in, and the contract executes itself. There's no debate over who performed. It's, you have very specific checkpoints, very specific acts. And the contract, understands what happens and when, money's in escrow, etc. And the contract effectively executes itself.
那智能合约呢？其实它就是把合约变成程式化，然后呢，它就执行了所有的事儿了。你合约上的这个相关的这个步骤，它用流程管理，它用结构图，然后这个很多的这个他们的逻辑运算，它就帮你做好。所以很多律师的或者是律师助理的工作都不这样。
But the challenge is with a smart contract, it's very binary. It's very yes, no. Did this happen? Did it not? And then it moves to the next step. Unfortunately, in life, in agreements and disagreements, it's never yes or no. It's yes, but, or no, maybe. There's always the gray area in between.
那智能合约呢，基本上就是 yes no 这个流程啊。但是呢，他说他是不是真的能够把法律的很多的业务都把它 cover 在里面，就让两造双方可以执行的？因为其实人生很多事不只是法律，不是只有 yes 跟 no， 有些才会有某一些的条件在。
So you'll have situations where parties are entering into these smart contracts, but there can still be disputes over what is the exact meaning of this term. And a computer program can't debate what the term means. The program can only tell you what you tell it to mean. So there still exists a challenge to these smart contracts that there's ambiguities that still require translation or understanding or debate. And then at that point, the smart contract is not so smart anymore.
然后，所以智能合约很多时候还是需要人帮忙，就好像我们说有了 AI， 人工作不会掉了，只是比较低阶或者不在了。但是你越高阶，它还是需要你去教它，然后判断很多的事物。
And a third issue coming up from AI and machine learning as well is inventorship and ownership. A number of companies now, for example, even with the patent drafting, a number of these programs or technologies now will create new content on their own. For example, there exist technologies where it can write the song on its own. You give it a pattern, like a tap pattern, or you hum 4 bars, and then from that, it'll develop an entire song, or it'll actually even develop lyrics based on a corpus of words and lyrics and poetry that might exist out in the public domain.
那大家知道那个未来初音，对不对？那就是说机器学习，它现在也可以自己帮你创造歌曲，然后帮你创造很多的文章，做什么？所以在这里面，未来的这个权利归属变成另外一个新的议题。
So the question then becomes, who owns the output of this program? If the computer creates the song, or the computer creates the lyrics, is the computer the author? Is the computer the owner? Or is it the person that put the original pattern into the computer? Or is it the person who programmed the computer and wrote the program itself? So there now exist these questions of who is the creator, who is the owner, who is the inventor?
所以现在就是他刚刚讲的，原创人、拥有人，然后专利权人这件事就变得比较混淆。是写程式的人，还是把拥有专利进去这个程式的人，还是机器创造出来这个音乐、这个文章，那这个机器变成作者，或者是发明人、权益人，他应该有他的配属在，这个就变得越来越复杂。
So, we sometimes joke, is the end of the day, who is our client? Is it the computer, or is it the person who actually wrote the program? So.
那以后你的客户到底是机器人还是人，你可能都还要质疑一下。
The other big change, the other big focus we're seeing with intellectual property that's changing the legal profession is with analytics and big data. And we saw in the presentation for Rico earlier, the amount of information that we look at. And prior art searching has been something that's always been out there, for example.
那另外就是大数据分析跟预测性的一个未来的一个规划，所以比如说先前技术的检索。
But the level of detail we now look at today with, for example, prior art searching just by itself, it's much, much more than just finding a reference that invalidates a patent or two references that make obvious a patent. It's looking who owns it, what's the history, what's the prosecution, what prior art did it cite, what art units did it, what countries did it in. Does it come from an IEEE paper? Does it come from research? Is there a product? It starts looking at a whole much larger universe over space and time than just, is there a patent that invalidates?
所以现在检索专利已经不是说找了一些前案就把专利无效或判断它是不是有这个进步性这些，但是呢，现在牵涉到很多你申请的过程发生过什么事情，然后呢，你有没有被人家修改过啦，或者是你在这专利的整个历程里，这都非常的重要。
And similarly as well, not just with prior art, but for example, determining what to even patent. There's programs now or analytics now that look at should we even file? What's the odds? What's the percentage chance that we'll receive the patent? What happens if it goes into a particular art unit or goes to a particular examiner? What's the odds that we're going to get a patent at the end of the day?
那所以刚刚另外提到，就是说你到底在哪里申请，什么时候申请，送给哪个审查委员，什么时候放进去，所以这个大数据的预测都会在这上面做一些的帮忙跟预测分析。
So we're starting to see a system where it's much less of the intuition and much less of the experience of the attorney. It's becoming much more of the output of a program that was written by somebody who most likely was not an attorney. It's simply a data analytics system at this point.
那所以以后律师的助手可能就变成一个跟这个行业完全不相关的大数据机器。